Let's get started. So just to make you all aware, we are going to record this session. So you're being recorded. So the goal of today's meeting is we're kind of at a turning point on this journey with the church. I think it's a really good time to recap the work that we've done so far as SRG and as mostly work within the board and work with Peter, but then also to sort of share potential next steps and potential timelines that could go a lot of different ways. But also, and then also just to answer your questions. I think we've had like some stuff happening and then quiet and then some stuff and quiet and sort of just give you kind of that full picture and get questions answered. I think we review this project basically every month as a board, and so it's fresh in our minds, but I think that if you're not in every board meeting, you're probably not as familiar with things. So I think repetition is really good here. So I want to just kind of start from the beginning of the this chapter and kind of share with you where we've gotten so far. Okay. So when Adriana was president, ComCom started a list of problem properties in the neighborhood. And at the top of that list was this church, right? No surprise there. I had reached out to our building inspector at the time. That's when he was like, this is my most reported building. So I'm glad you guys are looking at it. Adriana was a lawyer, he was president at the time, so maybe we sent a letter and so on, but he was moving out, and I was moving into that president role, right? Through kind of my network, I got in contact with Peter Hoffman. Peter, we came out, kind of looked at the project and looked into it a little bit and said, hey, this is such a prominent building in your neighborhood, you see it from multiple highways, coming down from downtown, everybody knows it, it's your entrance. He offered to help us as a neighborhood, given the new laws that went into effect about nuisance properties, to help us pro bono. To take on, at the end of the day, just getting this stabilized at the bare minimum. So, and I sent you all out the email, kind of the timeline. So in March 2025, we sent a soft letter to the owner. Owned by it's an LLC, so we found the owner and said, hey, these are all your list of violations associated with this. Can you please fix it? Sent that out 30 days later. In May 2025, notice of intent to file suit for injunctive relief, appointment of receiver within 60 days if violations not addressed, right? So that went out in May, said, hey, fix your stuff, otherwise we're gonna move to file suit. No response. Along that, parallel to that, Peter looked at our bylaws and our mission and said, okay, let's make sure that your mission has the strongest possible language to stand up in court for these laws, right? So we presented, the board voted to present these additional 3 amendments to our mission. We put that out in front of you all, we gave you all 60 days, we voted and approved those additional amendments to our mission. That went into effect in August. And so then in September of last year, we filed a lawsuit in the city of St. Louis courts. You can now follow this lawsuit on CaseNet. Just search Soulard Restoration Group. We put the case number in the email, everything is there. Serving the registered agent or the owner took us a while. So from September till January, nothing really happened. We didn't have anything to report because we couldn't get it served. But in January, agent was served and had 30 days to respond. On day 29 here, like he said, denied violations. He's like, no, this is not, I don't know what denied is, it's clear, right, what's going on. So in March 26th, which was like just end of February, beginning of March, motion for entry was granted for 60 days in preparation for appointment of receiver. And so that motion gives us access to this building for us to document the conditions and develop a scope of work in getting the building ready for a receiver to take it on. So that's the timeline of where we are now. And so we're actually really close to moving this into a redevelopment project. I think there are a lot of questions around who owns the deed for this property as we move forward. What's that gonna look like? What's the liability for the neighborhood for SRG? Now having to potentially manage or take ownership of this. And so I thought it'd be a really good time to get in front of you all to ask you questions, but then also have Peter give his legal expertise as to how this can translate. Alright, so with that, questions?
So was the building insured? If it was insured, was there a settlement? If it's a settlement, where is the money? And if he has the money, who's getting the money back?
Okay, so I don't know if Peter, you wanna take this, but
I can try to answer all those questions.
so my understanding, you looked it up, was that if the building was insured, the bank took that insurance payout and paid off the loan at the bank. So the owner didn't have a mortgage anymore, his mortgage got paid off and he just owned the building.
That's my understanding as well.
Yeah.
So they are not, I don't think there's any other proceeds that the owner is gonna get to continue the repairs. I think he got paid out, when he got paid out, dealt with the debt, had an opportunity to sell the property, didn't, he could still potentially sell the property.
So he still has the deed.
He still owns it. He'll own it the entirety of this process. So what the court takes away is, we sometimes explain owning property is kind of like sticks in a bundle. There's not just one right, there's a bunch of different rights bound up in that. What the court takes away in receivership is pretty much all of those sticks except for title. So legal control, responsibility for the property to improve it will be taken away and given either to the neighborhood or to a third-party receiver to kind of mend them. And then he, under the statute, has an opportunity to compensate the neighborhood or the receiver for those improvements, get all the sticks in the bundle back, or if he doesn't, the court severs that last stick and transfers it to the neighborhood. So that's where we are.
And who is the neighborhood?
The client is Soulard Restoration Group. Sorry.
So then we become financially liable for that.
You could, if you chose to do that. We handle lots of these different cases and lots of neighborhoods do it different ways. I would say the majority of them will contract out those rights entirely. So the court will give you the right to control it, to possess it, to fix it. But all of the rights to do that can be subcontracted out to a private developer. And that's what most of my clients will do. Occasionally, some of them, if they're a large, capable developer themselves, like the Sales Community Development or Tower Grove Community Development, they have done enough projects where they will just do it themselves and not contract that out. So you have an option either to do it yourselves as the organization or just contract out all of those improvements.
So contract out means that we're financially responsible for that contract.
No, they are. I mean, you're responsible for enforcing and supervising and managing the contract. It's basically an arrangement where you say with that receiver, we are going to give you all of the rights that were given to us by the court to fix up this property. All of the liability, all of the insurance, all of that is yours. You will hold us harmless because in exchange, once you bring that property into compliance, which would allow us to ask that court for title, we would transfer title over to you in exchange for your improvements. So it's a way to basically, you all have the vehicle to bring the lawsuit as a nonprofit with these special standing requirements that we amended in your articles of incorporation. A lot of private developers do not have legal standing to bring the suit, but they have a different set of skills. They have the ability to rehab property, experience doing that, access to capital, construction crews, all those types of things. So it's a partnership, really. It would be a contract between the neighborhood and this developer that says, you do what you're supposed to do in this way, under this timeline, and pull permits, and cover liability, and make sure you hold us harmless, and in exchange for once you brought into compliance, we'll transfer your title.
And in your experience, there's like limited defaults on these contracts.
So we try to, lawyers are always thinking worst case scenario. What do we do if something happens? How do we get out of it? How do we discharge the receiver? So we usually will have a bunch of different provisions in there. Worst case scenario, I've had a receiver, for instance, this was a more grassroots neighborhood group who hired just a private mom and pop guy to fix up an abandoned house in, I think it was Dutchtown. He had a serious health problem during the period of the receivership, and he had to ask to be discharged. And so what we asked is, okay, we will either find a new receiver to maybe replace you and compensate you, or we can, if the time allows under the law, we can ask for title and transfer that to you if that's what you decide to do. So there's ways to discharge a receiver, there's ways to replace a receiver, there's ways to buy out a receiver if you need to do that, and your contract will have all those different options sort of spelled out.
When you say our contract, that even the SRG contract, is it like, maybe you could explain what typically it would look like if we take submissions from various interested parties and developers all at one time and choose based on what they are proposing, or do we give them the parameters, and are we liable in terms of any risk for, having to carry insurance on this at this time, or like what's our?
You can contract out all of that risk and require that the developer who's doing the job carry all of that burden and pay for all that burden. Usually there is a negotiation and a meeting of the minds between the neighborhood and the developer. So the developer might say, here's what I think I can do with this property, here's the scope of work I'm willing to put into it before I can get title to it. Maybe they're willing to commit to certain uses, certain timelines, certain standards. In a neighborhood like this, it has a historic district, you probably want to put in there, for example, that they abide by all the historic registration requirements and permitting requirements, and and there's just boilerplate language we'll include in there too about keeping taxes current, keeping the property free of weeds and overgrowth and trash, and having a single point of contact for property management issues that might emerge during the period of receivership. But those things are really kind of negotiated between the neighborhood and the developer on a project-by-project basis. Sometimes we'll call them memorandums of understanding or community benefit agreements. What is the value of the project versus what is the community need and expectations, and how do we find the compromise there where the receiver is willing to take on a project. This one, I think, you all might be able to ask a lot less of that particular developer because it's such a huge project. But it's a negotiation, and I can share with Amanda some templates that we've used before. But we'll go through each of those and make sure that both parties understand the terms of that contract and who's responsible for what, who is responsible for what, when we get to that point. But you all choose, and I would recommend at this point, now that you have 60 days to get into the property, don't put all your eggs in one basket. I would invite multiple developers to look at the project and submit proposals to the board. You all can say, we really like this one, we think they're reputable, or they're maybe willing to, I don't know, do some extra landscaping or make some other agreement that you all find to be a priority, and opt to go with that receiver. But I think it's always good to have options, right? The more choices you have, you can kind of decide as a board who's going to be the best fit for this project, for our community, and then that's who you would enter into the agreement with.
I heard you say timeline. I think it's understandable that obviously our biggest concern would be to sign up with someone and then it just doesn't work out. And just you go, oh gosh, now we have to find somebody else.
Yes, I always encourage the parties to, you want to be reasonable. You don't want to set yourself up for failure and say this is going to be done in 2 weeks. but let's really be serious, build in some wiggle room there, and there's always unknowns in projects like this, but the standard under court supervision is not full renovation. It really is what I call a code abatement plus standard. So how do we get this property cleaned up, stabilized, safe, not ugly? Anything that smells bad taken out, anything that's dangerous removed or shored up. That really needs to be the scope of the work for the first phase. And you do want that to move through the court pretty quickly, I think. The sooner the better, because once you're out of court, that really opens up financing options for the receiver too. It's very hard for them to find capital for these projects under a court order. It's very unconventional for banks to lend when it's in court. So that's always a challenge. And so most of the time, the receiver will also want to move this through quickly. Let's get out of court, let me get into title, so now I can borrow against the property if I need to get additional capital, or sell it off to recoup my expenses for stabilizing the building. And you can put certain controls in place too, that you all have an option and get to meet with potential buyers if that is that receiver's plan.
When it was listed on LoopNet, I assume this is when the owner was trying to sell it. It mentioned that there was 3 standing buildings and 2 parking lots, I believe. How much of that is
It's in the
this?
suit. No parking lots. This is one parcel. The parcel is the church. There are 2 buildings on that parcel. The other parcel is a rectory. So it's just the rectory and the church. Unfortunately, these laws don't work really well on parking lots. So what gets you in the courthouse doors if the property is a nuisance? It's really hard to find parking lots to be a nuisance. If there's trash or dumping, they file suit, they go pick it up, lawsuit's over. But here, they would have to spend a substantial amount of money to eliminate the nuisance. So it really is only an effective tool for being a structural system.
How likely do you think it is that we'll find a suitable developer willing to take this on?
Good. So most of our work this is outside of our main focus area. Most of our work is in kind of middle neighborhoods and lower income neighborhoods. And it is really hard to find receivers in weaker markets. This is a very strong market. It's very high visibility. There's probably lots of good press associated with it as well, which is good for a developer's business. There are a tremendous amount of assets over you all. For one, I mean, the fact that this many people in the community come out to understand a project like this and care about a project like this is really encourages, I think, developers to take a chance even on a more expensive, bigger project like this. Restaurants and businesses, and it really is. I think there's a lot of potential here. It's going to take some outside the box thinking, but I think I think there's a good chance that you got to remain optimistic about it. So can't put a number on it, but I would say good. There's a lot going for it.
What is the stability of the structure now?
I don't know. So that's what the next 60 days is really gonna help us determine. So finding contractors that can go in with engineers, do a scope of work, understand all of those issues is really critical. That's why the court allows this kind of inspection documentation period to understand, is rehab even feasible? We have gotten into projects before where the court will allow us entry, we'll go in and we'll find termite damage, or some structural damage, or water damage, or foundational issues. And after talking to 5, 10 different developers, nobody can make this work. It's too far gone, it has to come down. The court can authorize the receiver to demolish the property or to partially demolish the property too. The lawsuit allows elimination of the nuisance condition. So if that means eliminating the parts that are structurally unsafe, shoring up the rest of it, that's going to be enough under the law. So you get a little wiggle room on the scope of work if that's the case.
And where's the wiggle room with the Historical Preservation Society? Can you repurpose the building something other than, I guess it would be a wedding venue?
It could be a wedding venue. So there's cultural resources and neighborhood preservation. In my experience, the city is pretty sympathetic and willing to work with neighborhood groups, especially when you have talked to multiple developers. And you have broad community support, you have aldermanic support. All of those things really help the city to be more, I think, realistic about what's possible with that property. So there have been maybe, in my experience, 8 years here now in St. Louis doing this, we've probably had to pull down 4 or 5, and there have been a couple where cultural resources is like, no, and then we say, here's the evidence why, and they say, okay. So we kind of have to cross that bridge when we come to it, but in my experience, they've been pretty reasonable. If we try everything, they know that a group like this, I think, is not out here to just demolish this and turn it into a parking lot, that if there's a possibility of saving it, you're going to try to do that. So that's just been my experience.
And just for your awareness too, the board, and I've been keeping in contact with our partners on this. So Jamie, our alderwoman, she knows all the updates, every change, I sent her an email. You know, we did some press to get some more visibility on it. So we are already sort of have our relationships established and understanding for this project.
And this would also most likely qualify for state and federal.
Tax credits, yeah, and I think that's that's a great point. I think that's something you're gonna wanna talk to that receiver about too. The good receivers are gonna explore those options. They're not gonna leave that money on the table. And why wouldn't you use it for a project like this? This would be a great candidate for that, so.
And thank you, by the way, thank you from all of us for doing what you do.
I have the best job.
We always
All
like
pleasure,
to
all
you,
mine.
you know.
Why does the SRG want to get involved in this?
Well, you can probably answer that better than I can.
Why does the SFG? I mean, we want to save the building. I think it adds a lot of value, can add a lot of value to the neighborhood, and I think we want to try as a neighborhood association. I think we're in a very strong position given the current laws to pursue this avenue. I mean,
Is that something this organization should be involved with?
it's in our mission.
It's kind of what we were founded to do. is-
Yeah, I mean, why wouldn't we try to save this? If we can't save this church, what other neighborhood up there can?
Not to mention, it's such a highly visible,
That's right.
and, you know, it's not like it's just a little house around the corner, it's right out there.
It was functional, it was adding value up until 3 years ago, and it died.
I will say also that the city's tools for addressing problems like this are really limited. I mean, I'd rather be on the beach somewhere retired and not having to, you know, fight with some of these owners all the time over this stuff. But thinking that the city's nominal fines are going to get this owner to bring the property into compliance is just hard to believe. And you can see it all over the city. There's 9,000 vacant buildings that look just like this. And really the tools that are available to you all as a community organization, as residents, as people who live near this building are way more powerful than.
So how much money is that gonna cost the SRG, while we're waiting for somebody to do something?
Nothing.
Nothing.
So that's why I asked the question. I hear you,
Yeah.
and that's why I asked the questions I did at the beginning, because if it's going to become financially burdensome, it's not our place, but if it won't be, and it falls under historical guidelines and code, then I do think it is our place.
Okay, and what about the safety to the public? That whole south wall is.
So that's what the developer is
is-
determining. You
is-
can't get us, you can't.
going on.
But that's why we're doing this. That's what they determine.
Right now, all liability is on the owner. The group, the way we'll set this up is the neighborhood group will have no liability for this at any point. Just because you've sued and made a claim on that property doesn't vest you with any rights or responsibilities in it yet. Now, we are asking for a judge to vest the neighborhood or its contractor, the neighborhood and its contractor with those rights.
Has there been a feasibility study on what this is gonna cost to renovate?
Well, that's what the next 60 days will do, and that's what we'll find out. What is the cost? What's the scope of work? What's the timeline? Is it feasible at all? And hopefully you'll have a handful of different proposals here to make up your mind in the next 60 days. Is this even a viable project? And if it's not, you know, the other thing you can do, again, you can try to get it demolished, and get
That
titled
costs
up.
too, though.
That costs money too, but at the end of the day, you own the land.
Yeah.
You get it away from this owner who's not doing anything with it, which is an upside.
And the rectory is still pretty much intact.
We think so.
So you're only demolishing the church if you're demolishing.
Right.
The rectory didn't get any damage. It's a perfectly fine 3-story.
So is there any kind of gray area between when we acquire it and a developer actually takes it on, where if it even needs to be tarped at this point because, you know, it's gonna rain on, it's another rain at this point? Or, you know, you say we never have liability, like if somebody walks by and the brick flies off and hits them in the head.
No, I mean, you're gonna outsource all of that
Okay.
liability to the developer. So my job is to make sure that you don't have any exposure at all for any of those things. Most rehabbers or developers will put together a plan that's usually, here's what we're gonna do in the next 2 weeks, here's what we're gonna do in the next month, 3 months, 6 months, 9 months. And those things are usually first shoring it up, cleaning it up, gating it, fencing it. Those are the types of things you're gonna wanna look for in a rehab plan. And then, you know, because they will need to go to the city and get permitting. That's gonna take some time too, so maybe a little longer window for that. We always encourage, in the samples I can share of development plans, usually do have a sort of phased development to make sure that we're taking care of immediate safety risks at the time control of that property is transferred.
A 3-part question, Peter. Number 1, legal services is providing this free of charge.
100% free. Do
Amazing.
not charge.
Let's say, worst case scenario, we get in there, we look at it, we look at the developers, it's just not working out. Can we just dismiss the case, walk
Good.
away, it's free, no problem?
Yeah.
Awesome.
Right.
What do we need to do to get this committee formed?
So we're gonna be at the next board meeting, setting up ad hoc committee for it. We're gonna have names, so we hope to have at the next board meeting an ad hoc committee formed, and would love for you, like SBA representation on it would be awesome, so.
I thought we were not here, my bad.
What's
I
that?
thought we were forming the committee today, so my mistake.
Well, are you interested, like, let us know. So I sent the email out, I think, as a board, we just have to align on it. But yeah, that should be coming.
Were these photos recently taken by the developer that's interested in the property?
No, these are older photos.
Okay, so like after the fire actually happened?
Yeah, well, no,
They're on Zillow.
yeah.
Oh,
It's
okay. That's pre-fire.
So there is an interest in development.
So we have an interested receiver.
Right. There is a national group who are experts in this, California Receivers Group. There aren't a lot of programs that do what we do around the country, but one of the larger ones, kind of our sister program to ours, operates in Memphis. And they've used California Receivers before. They really specialize in larger projects like that. They are going to come in and look at it and do a scope of work. But like I said, you probably don't want to put all your eggs in one basket. You have other development partners, even, they could be business entities within the neighborhood or other developers who are, I think you want to shop it to as many people to look at as many different proposals to find the one that fits you best. But
The one
there
you're
is one for
talking-
now. Yeah,
The one you're talking about, the
California Receivers Group, yeah.
Are they a middleman in the sense that they acquire it and then find a local developer, or do they actually develop?
They are kind of the middleman, so they specialize in receivership. So it's a unique piece, right? So it's not like just buying a house on the market and fixing it up and selling it. They are their area of expertise is working under court-appointed receiverships, which means finding creative ways to bring money into the project. So they've kind of developed a pipeline to bring money in while the property is in receivership, shore it up, and then get title to it, and then move it back to market. So
Well-
that's kind of their
For instance, this may be jumping too far ahead, but if we were to go with this particular scenario.
Yeah.
And they now have ownership, right? So we're no longer have any say because they'll also, it'll be their job to find a developer.
After they stabilize it.
Oh, right, and then they can say, well, they didn't find anybody, like time goes by and like nothing's happening. Do we have any say ever that?
Oh,
you
yeah.
guys-
Yeah, so your agreement with the receiver is gonna, it was kind of the other question, what happens if we need to replace the receiver?
Yes,
Or if they don't do what they're supposed to be
Right,
doing,
right.
then you've got contract rights there.
Okay,
We can build those as strong or as weak as you all want them to be to make sure that they're responsible for that property once they're appointed receiver, and if they're not doing what they're doing, you have the ability to discharge them and find another receiver or dismiss the case or whatever you need to do to find somebody else.
have you ever looked at this particular?
I have not worked with this particular group before. I have worked with their attorney before,
Okay,
who runs a similar program to ours in Memphis. He's very well respected and he's a really smart guy. So I'm willing to
Yes.
kind of see if we can lure them into this market to do this.
So we haven't done anything else in this area.
He's not in St. Louis.
and out of this size apparently, right?
Okay, so if you have one interested party, and you want to get more interested parties, you recommend like an RFI or an RFQ or an RFP process, and if so, does that fall to the committee that you're trying to put together, because that will take time and resources to do that?
But if we wanted to do that, you can recruit by word of mouth, you can recruit by email, you can recruit by networks of developers, or you could do a request for proposals. It's up to you.
And just to put out there, I do some development work on distressed properties. This wouldn't be appropriate for us. But the community of developers in St. Louis is pretty small. So once we have a clear idea kind of what the scope of work is for this project, you don't have to do a lot of work for all the developers that could do this project to become aware of it. It's not necessarily a heavy lift in terms of getting it out there.
So who determines the scope? Who's going to determine the scope of work?
So the receivership company is coming in they're bringing in contractors, they're gonna get multiple people in to develop that scope of work. And I've got a photographer coming as well to document condition.
I'm just asking because if we want to have multiple, if we want to put an RFP or something like that, we have to.
Yeah.
That's right.
Exactly.
Yeah, maybe having somebody with construction experience on that committee to review different proposals is
Yeah.
a wise idea, because then they could say, I've done projects in St. Louis, I know this scope is, so this is a really great scope. And there are other resources. I know Tower Road Community Development, who has worked with us on many, many, many receivership cases here. They have done that for other neighborhoods, offered to look at a scope. There's other nonprofit groups that I think would help. But yeah, tap into your local skills and experience here of people who do work in the neighborhood who can tell you, this is a pretty sound scope, or they need to adjust some things before we approve this.
And so right now we have Kevin King, tapped to lead this committee. He's rehabbed over 10 historic rehabs, both in Soulard and Bennett Park. He has been working with us so far on the project, keeping up to date, and he's happy to sort of lead this committee that we're putting together, this ad hoc committee for this phase.
So I'm still a little bit confused. So at what point is
In
the
the
original owner not the owner anymore?
Not at the end. He remains the owner all through receivership. Receivership is, we're taking sticks out of that bundle, we're giving control to somebody else, neighborhood or contractor, they're gonna fix it up. Once that property is brought into minimal code compliance, we file a motion for title. Once the judge grants the motion for title, that is invested in the neighborhood and the title transferred over to the receiver.
So who pays for all the work that the receivers are doing?
Receiver pays for the work.
And then they get ownership.
They get ownership.
But
But isn't there a clause too, though, that if he comes back and he wants them to keep title, he has to pay them?
That's right.
Yeah.
So it's the United States, property rights are sacred here. Owner's always gonna get an opportunity to get their property back. And so if it means the receiver spent $180,000, $500,000, he's gonna have to show up to court within probably a pretty tight timeline with those funds. He'll also need to explain why he didn't offer his own redevelopment plan, why he was not responsible for the property, why he allowed it to deteriorate in these conditions. It's very tough work. I have probably handled 1,500 of these cases over the last 15 years, and I've had two where the owner has come back and compensated the receiver. It doesn't usually happen, but it can.
If that happens, would we receive any remuneration for all the effort we put into it?
No, but
Wasn't yours effort.
but what you can do is make sure that if they get that property back, that it's done, in a way that they finish the rehab. That the court's not going to hand them the property back over if they don't have the resources to finish the job. If they ask for control before the end of the process. So, I always say, sometimes this is never the goal of the lawsuit is never to take property away from people. It's sometimes a secondary consequence. Most of the time, the goal is just to get the property abated. And I can say in all those cases we've ever brought, the outcome has always been we're going to get that property to code abatement one way or another. We're going to get we're going to get it safe either by that owner or by a receiver.
Do you have any gut feeling about having dealt with this owner, do you have any gut feeling about George?
I'm positive about all. These cases take a lot of time and effort, and I wouldn't do them if I didn't believe in the neighborhood, I didn't believe in the project. So, I feel good about it. Let's explore it. Let's bring people to the table. Let's show the city what we can do. And, and hopefully inspire others to do the same.
Well, at this point, if you're a developer and you're interested in this project, where are you in the lineup of stuff? Are you waiting to see who gets receivership? Can you get receivership, or are you at the mercy of the deputy and then the receivership, or what's?
Yeah, so the receiver would have to work with the neighborhood association, with Soulard Restoration Group, to inspect the property. So we are going to document to the best we can. And hopefully that will save a potential receiver time from having to get in and out and kind of avoid doing that with the condition of the property. So we'll take pictures, but if they need to get back in, we can always go back to the court. Let's say in these 60 days, we have 2 or 3 receivers who are interested. Let's say you don't like any of those bids. You say, no, let's keep shopping it. Let's look around, let's maybe find a developer from across the river somewhere. You can go back to the court and say, we need another 60 days to inspect. And that will allow you more access to the property if you need it. Again, time is kind of the essence. The building dangerous, you probably do want to move it along. But the court's going to allow you more opportunity to get in there so that you can show it to receivers. But hopefully that those pictures will be helpful and save them some time.
Likely by the year or someone from your legal services office, just maybe you remember that. It's about 7 or 8 years ago came and presented what you actually do to the board, so I appreciate your speaking with us.
It was me. It was his all I do are these cases.
I thought it was
And so we are seeking, if you are interested or know somebody that's interested in joining your network, come talk to us. We want as many bids, as many potential, results for this, to assess for this church as possible.
When are you going to be doing a walkthrough?
So the tentative date is the 25th.
25th from 9 to noon, 2 weeks from today, right?
Yeah. But we don't want it to be a free for all. I think this clearly is a damaged building.
Yeah.
We'll have waivers.
Waivers.
Yeah, we'll have waivers.
Oh, is it gonna be
Liability.
open to some of the residents? Yeah.
No, I
I'll share those pictures.
Yeah, you can get the pictures. I think the motion for entry is very specific around doing a scope of work. So if you're not doing a scope of work, we don't want you, hanging out there.
But you'll provide the information afterwards too.
Yes.
Thanks for your time, Peter.
Yeah, thank you.
Pleasure's all mine.
We've done,
Thank you all.
it's been a long journey, but now we have a say. The neighborhood has a say on this.
Yeah, and the other thing I'll add is, this defendant, his attorney was his brother, did file an answer, on the 29th day. But he did not show up to the status conference the following week. And he did not show up to the hearing for entry the week after that. So I don't know at this point how engaged they're going to be. Sometimes it might be the best case scenario if maybe he really hasn't been in the property and just has walked away from it. He got out of it what he's going to get. Why pay taxes? Why pay maintenance? I'll just walk away. So that might make things go a little bit more quickly. If he wants to fight over it, he can fight over it. But the statute actually filed under all of them say that this gets expedited treatment in the court. So because it's a dangerous building, we can't let it sit. We should try to move it. And the process will allow for that.
And so just FYI, the sculptor who rents next door to this neighborhood school is interested in this church. So he's said he's interested in talking to anyone who may be interested in learning about what he wants to do. So just wanted to share that piece of information.
I don't know what his current status is with the DEA investigation, but that's certainly a factor.
Yeah, there's no federal liens, there's no bankruptcy. Sometimes they'll file bankruptcy to try to shake off these lawsuits. Those usually don't work, or delay things all that long. There hasn't been any of that, it's just been silence, so. Maybe he has bigger problems. Which is hard to imagine, because this is a pretty big problem.
Well, thanks, Peter.
You're welcome.
Thanks for your
Thank you
time.
all.
Thank you.